Hello and welcome to today's employment law update with Keeley Baigent of KSAB Law. Today we're going to cover case law developments in the last 12 months and the holiday pay law changes that came into place in this January. So the session today will be recorded and sent to you in the next week. Please feel free to ask questions as we go along in the chat box and we'll answer them as soon as we can. So I'm going to pass over to Keeley and I hope you enjoy the session. Thank you. There you go, Keeley.
Great, thank you very much. Yes, hello everyone and welcome to today's HRHuddle. As Eloise has said, the focus of today's huddle will be on the new holiday rules. But if we have time after that, hopefully, I will also speak with you about the new legislation which comes into force this year. So I'm going to share my screen and share the slides with you. So beginning with the new holiday rules then, and where this all started was further to the UK's withdrawal from the European Union, if we can cast our memories back that far, which of course was pre-COVID. So following the UK's withdrawal from the European Union, a new category of UK law known as retained EU law was created under the European Union Withdrawal Act 2018. And that consisted of the EU-derived law that applied at the end of the transition period on 31st of December 2020. It included many pieces of domestic legislation implementing EU directives, such as the working time regulations, also the European Court of Justice's decisions called the retained EU case law, and then also domestic cases on the application of retained EU law called the retained domestic case law. Retained EU law applied from 1st of January 2021 to the 31st of December 2023. And with effect from the 1st of this month, Section 3 of the Retained EU Law Revocation and Reform Act, known as REAL Act, ended the supremacy of EU law. So any retained EU law that was not revoked by the REAL Act became known as assimilated law. On the 8th of November 2023, the government announced a reform to the law on holiday under the working time regulations to coincide with the coming into force of key provisions of the REAL Act on the 1st of this month. The package of measures relating to the holiday rules or the change to the holiday rules resulted from two separate consultations. And we looked at these in our previous updates. The first of the consultations was called Calculating Holiday Entitlement for Part-Year and Irregular Hours Workers, and this was published in January last year. The consultation was a direct result of the perceived unfairness of the Harper Trust and Brazil case. The consultation stated that as a result of the judgment in Harper Trust and Brazil, part-year workers are now entitled to a larger holiday entitlement than part-time workers who work the same total number of hours across the year. The government is keen to address this disparity to ensure that holiday pay and entitlement received by workers is proportionate to the time they spend working. So it's all about the proportionality and the perceived unfairness that resulted from the Harper Trust case. The second of the consultations was called Retained EU Employment Law. That was published in May last year, and this primarily dealt with the calculation of holiday pay. So at the same time as the government announcing this major update to the law or the working time regulations, it also published some draft regulations to implement the changes. The regulations are called the Employment Rights Amendment, Revocation and Transitional Provision Regulations 2023, and they're referred to as the ER regulations. They came into force on the 1st of this month. In addition, this month and only last week, the government has published guidance on the new holiday provisions that are brought into effect by the ER regulations. So what we'll do during HRHuddle is we'll have a look at the ER regulations, and of course then we'll go and have a look at, I'll go on to have a look at the guidance that implements and helps and assists our understanding of the regulations. So before we look at the ER regulations in detail, I want to cast our minds back to the Harper Trust case, because it's necessary to consider that case and look at the problems with how the working time regulations operated at that time, to then be able to gain a more complete understanding of why the regulations were published this month. So, as I've said, one of the consultations that resulted in the holiday law reforms was a direct result of the Supreme Court's decision in the case of Harper Trust. So, as I say, let's have a look at that decision briefly before we go on to look at the regulations. The case was decided in July 2022, and we looked at it in detail last year. The background to the case is the unamended working time regulations, which say that workers in Great Britain, including part-time workers, have a right to a minimum of 5.6 weeks annual leave per annual year. So annual leave year. The legislation prescribes that workers are entitled to be paid at the rate of a week's pay in respect of each week of leave. Now, how this applied in practice was difficult. Some employers, prior to the Harper case, some employers took the approach of saying that holiday entitlement accrued at the rate of 12.07% of hours worked. And this derives from the fact that the standard working year is 46.4 weeks. That's 52 weeks less the statutory 5.6 weeks. And 5.6 weeks is 12.07% of 46.4 weeks. This used to be the approach that was recommended in the ACAS guidance booklet, and that's before the Harper Trust case. However, that guidance has now been removed. With regard to pay during annual leave, so that's how some employers accrued the leave. But with regard to pay during the leave, under the unamended working time regulations, a worker's holiday pay entitlement is a week's pay for each week of leave. So if a worker doesn't have normal working hours, a week's pay is taken to be the worker's average weekly pay in a reference period of 52 weeks before the calculation date, which is the first day of the relevant period of leave. Any weeks in which no remuneration was payable are excluded, and earlier weeks brought into that reference period. So what are the facts of the case? So the facts of the case are that Mrs. Brazil was a visiting music teacher at a school run by the Harper Trust. She was employed by Harper under a permanent contract on a 0 hours basis. Harper was not obliged to provide a fixed minimum amount of work, and she was paid only for the amount of work carried out. Mrs. Brazil worked mainly school term time. The length of the school term varies from year to year, but is between 32 and 35 weeks. So she was a part-time worker in two senses. Firstly, that she did not work a full working week, and secondly, that for large parts of the year during the school holidays, she did not work for Harper at all. And it's only this second time of part-time working, i.e. the part-year working, and with which the case was concerned. Mrs. Brazil was entitled to 5.6 weeks paid annual leave under the working time regulations. She was required to take that holiday during school holidays. As the school holidays are far longer than this, no particular weeks were designated as statutory holiday, But by agreement, Harper made 3 equal instalment payments in respect of holiday at the end of each of the 3 terms of the academic year. Following the ACAS guidance in place at the time, Harper calculated Mrs. Brazil's earnings at the end of each term based on the hours she worked and paid her 12.07% of that figure in respect of her holidays. So, Mrs. Brazil brought a claim in the Employment Tribunal for unlawful deduction in wages, asserting that she hadn't been paid enough for her holiday. She said that the 12.07% approach bore no relation to the calculation required by the working time regulations. She argued that her holiday entitlement should be paid at the level of her average earnings over the 12-week period, which increased to 52 weeks, immediately before holiday was taken. That approach would result in her as a term time only employee receiving a higher percentage of her annual earnings as holiday. So, for example, if she worked 32 weeks of the year over 3 terms, her holiday would accrue at 17.5% of her hourly rate or annual earnings. That calculation is made up by 5.6 weeks, this being the same as a worker working a full 52 weeks of the year, divided by 32 weeks rather than the 46.5 weeks, as with a full-time worker, times 100. Whereas other types of workers had 5.6 weeks holiday divided by 46.4 working weeks, equating to the 12.07% of the hourly rate or annual remuneration. So you can see in proportion, she would be receiving a much higher percentage of holiday compared with a regular worker. Mrs. Harper submitted that there was nothing in the relevant provisions requiring a different approach where the worker does not work a full year. So what happened then? Well, the tribunal actually agreed with Harper and they dismissed Mrs. Brazil's claim. And they said that a pro rata principle should apply and that the statutory scheme should be read down for part-time or part-year workers who worked fewer than 46.4 weeks per year, so that the payment was then capped at 12.07%. So Mrs. Brazil, she appealed that decision and the EAT and the Court of Appeal agreed with Mrs. Brazil. The AT allowed Mrs. Brazil's appeal and agreed with her, holding that there was no requirement in the working time regulations to pro rata holiday pay for part-year workers, and that it therefore should not have been capped at 12.07%. With regard to the Court of Appeal reached a similar decision to the EAT, holding that attempting to build a pro-rating requirement into the working time regulations would make it an entirely different scheme. The court stated that the calculation exercise required by the working time regulation is straightforward and should be followed, even if it results in part-year workers receiving a higher proportion of their annual earnings as holiday pay. Harper then appealed to the Supreme Court, and the Supreme Court dismissed Harper's appeal for substantially the same reasons as the Court of Appeal. So we were left last year in a situation where immediately employers were not able to lawfully pay 12.07% of an hourly rate as holiday pay for irregular workers and part-year workers, even though that then resulted in those workers receiving substantially a proportionately higher holiday entitlement than comparable regular workers. So what did employers do? Some of them took the risk. Some of them took the risk and continued to pay part-year workers and 0 hours workers at the rate of 12.07% of the pay that they received and the hours that they worked. Others renegotiated contracts, trying to get people on a monthly regular payment. to avoid the situation of the proportionality being higher. And then, as I say, other people just took the risk, or other people just took the average of the previous 52 weeks, and which then resulted in the higher payment to those workers. But who did the case apply to? It applied to really all workers, but it really affected, as I said, the casual workers, the 0 hours workers, and the part-year workers. So as I say, that then resulted in the consultations, which then has resulted in the new regulations. Before we go on to look at those regulations, it's worth reminding ourselves that historically there has been a distinction between the two pots of leave. So, as I said, the working time regulations require all employees to be given and workers to be given 5.6 weeks holiday per year. That is split into two pots under the regulations. So 4 weeks of leave, which derives from the Working Time Directive, has historically, and because of case law, been treated differently to the additional 1.6 weeks that derives directly from our working time regulations. As case law has developed, as I say, in the area and through Europe, there arose this difference in treatment between the two pots of leave. Although the consultation purported changes to that, so that going forwards, employers would be required to deal with the 5.6 weeks leave the same, i.e. the two pots of leave together the same, that hasn't materialised under the new regulations. So we're still in a position going forwards where we are still being required to treat the two pots of leave differently in respect of regular workers. So if you can still keep in your mind that there are these two pots of leave that combine to make 5.6 weeks of leave, the first being 4 weeks of leave that derived from the Working Time Directive, and then this 1.6 weeks that derives directly from our working time regulations. So let's have a look at what the regulations say then. In summary, the regulations amend the working time regulations to set out a new system of holiday accrual for irregular hours workers and part-year workers. This is intended to address those difficulties which we saw in Harper, whereby those workers were receiving proportionately a higher holiday pay entitlement to regular workers. The terms irregular hours worker and part-year worker are defined in the regulations and include workers whose hours are irregular, such as casual workers and some agency workers, and workers who under their contract have periods in the year of at least 1 week where they do not work and are not paid, such as hourly paid term time workers. Now that's key because they can't be paid for those weeks. So they don't work the weeks and they don't get paid for those weeks. So for leave years starting on or after the 1st of April 2024, for these workers, i.e. the irregular hours workers and the part-year workers, holiday will be calculated to accrue in hours rather than weeks, and will accrue on the last day of each pay period at the rate of 12.07% of the actual hours worked in that pay period. An average over a 52-week reference period will be used to calculate the amount of holiday that accrues during a period of sick leave or statutory leave, such as maternity leave. So employers, in effect, in respect of these workers, will now change the way that they calculate accrual of holiday. And they will calculate the accrual based on the pay period, the hours worked in that pay period, and they will calculate 12.07% of those hours. And that will give you then the figure for how much holiday has accrued during that pay period. In respect of maternity leave or sickness or any other statutory leave, we're going to need to use a 52-week reference period to calculate the amount of holiday that accrues during that leave period. I'll explain this in a bit more detail when we look at the guidance. So under the regulations, employers now will be able to choose from 2 systems of holiday pay. So we're now moving on to pay. So we've looked at how it's accrued, holidays accrued. Now we're looking at how it's going to be paid and how we're going to calculate the payment. So first of all, they can pay holiday when holiday is taken, and they calculate that holiday pay at the rate of a week's pay for each week's holiday. A week's pay will, broadly speaking, be the average amount of weekly pay over the previous 52 weeks, including the additional elements of pay set out in the modified definition of a week's pay, which we'll go on to consider in a minute. A week's holiday will consist of the average number of hours worked in each week of the same 52-week period. So this should, in effect, produce an hourly rate of holiday pay that reflects the average hourly rate of pay over the last year. Just keep in your head at the moment that to calculate payment, so an employee or worker accrues holiday, and a regular worker accrues holiday at the rate of 12.07% in that pay period. So you've got the number. Then you say, right, they're going to take their holiday whenever they make an application. You say, yes, they can take their leave. You then calculate the holiday pay. And in calculating how much holiday pay they should be paid when they take that holiday, you look at the previous 52 weeks of pay. Okay, the other option on payment, so this is the alternative, the other option on payment is to not pay the worker when they take the holiday. And instead, you pay them what's called a sum called rolled up holiday pay within their pay. So what that means is, and it's worth mentioning, you've probably remembered the term rolled up holiday pay historically. Employees did use it historically years ago. It was then made unlawful. So these regulations now bring it back into play. So rolled up holiday pay under the new rules is an uplift of 12.07% to the worker's remuneration for work done in each pay period. So such workers must be allowed to take that holiday, but will only be paid, but won't be paid holiday when they take that holiday. They will already receive payment for it. So it links quite nicely in to the accrual method, because what happens is an employer now could calculate the amount of holiday that's accrued during the pay period, take it as a month, by 12.07% of hours worked, and then pay the employee at the same time they receive the payment for that pay period, 12.07% of the pay to account for and make a note on the pay slip to indicate that that is their holiday pay. So then when they take the holiday, they don't receive payment. Now, since these new rules only apply to leave years starting on or after the 1st of April 2024, workplaces that run their leave years from 1st of January to 31st of December will find that the rules in practice will not actually take effect until 1st of January 2025. Now, my experience is most employers run on a calendar year as a holiday leave year. So for most of you who do operate like that, you're not going to be implementing these changes until 1st of January 2025. So it gives you a bit of time to get everything arranged and organised for that date. For those who operate holiday leave years the same as a tax year or from 1st of April, then obviously it will come in, it can come in straight away. So what's the definition of a week's pay for holiday pay purposes? So with regards to what should be included in calculating a week's pay, the new law provides for certain payments to be included. So a week's pay for holiday pay now formally includes, and it was in already, but it was in through case law, European Court of Justice decisions that have come in from Europe, and now it's being confirmed in the regulations that a week's pay for holiday now includes payments, including commission payments, that are intrinsically linked to the performance of tasks which a worker is obliged under their contract to carry out. So if a worker is receiving usual payments and it's part and parcel of their remuneration package, then that should be included in the calculation of holiday pay. Also, payments for professional or personal status relating to length of service, seniority or professional qualifications, and also payments such as overtime payments, which have been regularly paid to a worker in the 52 weeks preceding the calculation date. Now, I won't go into huge amounts of detail here, but you'll all remember the number of cases, I'm sure, that we have discussed about whether overtime should or shouldn't be included in holiday pay. So helpfully, the regulations are saying that if overtime has been paid regularly, and that word has come in again, regularly paid to a worker in the 52 weeks preceding the calculation date, then it should be included in the calculation of the holiday pay. The amended definition will apply to all holiday calculations for all workers, including part-year and irregular workers. However, I'll move on too quickly. However, it does not apply to the additional 1.6 weeks leave that derives directly from the working time regulation. So again, hopefully you'll remember when we've discussed cases in the past, we've made that distinction between the 4 weeks that derive from directive and 1.6 weeks that derive from the from our working time regulations. It's still the case that when calculating holiday pay, you can differentiate between the first 4 weeks or the 4 weeks and the 1.6 weeks in how you calculate it. And those additional payments, which we've just looked at, may not be included in 1.6 weeks payment. It might just be basic pay. Now, it's unusual for employers to do that, I admit, but some employers do. And the regulations confirm that they can still do that. And I think that is because the government is also concerned about increasing costs to employers and trying to, and if they had made all of the 5.6 weeks payable in respect of all those payments at normal pay, then obviously that could have increased further cost to employers.
Keeley, just a quick question. Is there any guidance so far as to what regular means, going a slide back?
No, but I think we can look at previous case law on that, which in some part is helpful, other parts no. I mean, regularity is, it could be every week, it could be every 2 weeks, it could be one payment each year. It's something that the employee reasonably expects on a regular interval basis. So that might be daily, it might be weekly, it might be every 2 weeks, it might be every month, it might be every quarter, but it's paid historically on a regular interval basis.
Great, thank you.
So the next bit I want to cover, you've done that, so that's the week's pay, is carryover rights and what the regulations say about carryover of holiday from one leave year to the next. The regulations do deal with this, and they restate the effect, again, of a series of European Court of Justice decisions in this area. So further to this, workers have a right to carry over if any of these following situations apply. Where they're unable to take some or all of their leave as a result of taking a period of statutory leave, that is maternity leave, family-related leave, then of course employees will be able to take over. And that's not just 4 weeks, that's 5.6 weeks from one leave year to the next. In relation to situations where employees are not able to take all or some of their leave as a result of taking a period of sick leave. Now, that carried over leave must be taken within 18 months of the leave year or the end of the leave year to which it relates. So there's a stopgap on that being able to be taken. So it's 18 months of the leave year to which it relates. That only relates to 4 weeks leave that derives from the directive. So you'll see some contracts, and I draft contracts in this way if employers want me to, that the carryover in a sickness situation whereby an employee is unable to take their holiday because of sick leave only relates to 4 weeks, the 4 weeks that derive from the directive, and it doesn't apply to the additional 1.6 weeks. Also can carry over where in any leave year the employer fails to firstly recognise a worker's right to annual leave or paid annual leave. Well, that won't be applicable to us. Give the worker a reasonable opportunity to take leave or encourage them to do so. So they leave, say an employer leaves the ability to make for an employee to take their leave until the end of December and they can't possibly take it, then that carryover situation would apply. Or if the employer informs the worker or fails to inform the worker that leave not taken by the end of the leave year will be lost. Now that's a new one. So keep that in mind. To remind employees or send emails to employees, and this can be a standard email that's sent, please remember to take your holiday this year, which ends on, because otherwise it will be lost. And if you fail to do that, then under the regulations, they could carry over the leave, which seems a bit unfair, but anyway, that's what it says. The carryover rights, as I said, only apply to the 4 weeks of leave that derive from the directive, with the exception of the maternity one, which applies to all of the 5.6 leave. And of course, for the irregular hours and part-year workers who we're looking at potentially accruing on 12.07% hours basis, that 12.07% calculation includes the 5.6 weeks. So they will automatically get swept into actually all these rights apply to their full holiday entitlement rather than just 4 weeks. So the final point then to mention on the regulations is the removal of the COVID-19 carryover.
Before we move on, just got another question. So somebody's asked if they pay on 0-hour contracts a month in arrears. So do they work, for example, in March and are paid in April? She's saying, am I right in thinking we include a holiday payment of 12.07% rolled up holiday pay from April, as this is the start of their holiday year? So I didn't read it very well. Does that make sense?
I know, I think theirs will start in May, won't it? Because their pay period is, so they pay March's work in April and April's work in May. So
Yes.
if their holiday leave year starts on the 1st of April, then the new rules will apply to that April pay, which will get paid in May.
Okay. Is that okay, Helen?
Because that's your pay period, isn't it? You're calculating March's work in April and paying for it in April in the same way as then April's work in May. So I think your rolled up holiday pay for April will be paid in May.
Yes. Perfect. Thank you. We have had another question as well. So somebody else has informed an employee who's on long-term absence that they're at risk of losing holiday if they decide not to take it. Is the company within its rights to write such leave that is, to remove such leave that's expired?
Yeah, I mean, if an employee is on the sick, they continue to accrue holiday. Now, the employer can alleviate itself from that continuing liability by allocating days to the employee to take as holiday during the sick leave period. They can do that. So they'd be better off to do that rather than to tell the employee you've lost your leave, because actually that goes against the legislation. So if they want to try and, as I say, rid themselves from the continuing liability, then they'll need to write to the employee and say, you've got X amount of accrued holiday. We are going to assign these days as your holiday, and you will be paid holiday pay for those days.
Okay, great. Hopefully that answers your question, Oksana. Thanks, Keeley. Carry on.
Okay, so we're just looking at these COVID rules, and thank goodness we eventually see the end of it, because I'm sick of hearing about it. But basically, these rules were introduced back in March 2020, weren't they? 26th of March 2020. The government introduced this emergency regulations, relaxing the restrictions on carryover of annual leave and allowing carryover of annual leave in situations where an employer prevented or asked their employees not to take leave in order to assist them during the pandemic. So that has continued. Those rules that were introduced in March 2020 have now been repealed as of the 1st of this month, subject to transitional period, whereby the workers have until the 31st of March of this year to use up any accrued holiday carried over under the regulations. So that's good to hear. We'll now have a look at the guidance, because in looking at the guidance, that will assist us in understanding the operation of the regulations. What I won't do is I won't cover everything in the guidance, because we'll be here forever if we do, but I've picked out certain things that I think it's worth looking at. But use it as a handbook. If you have situations involving part-year workers, irregular hours workers, go to the handbook, go to the DTI guidance, use it like a handbook, and it gives you examples, working examples that you can then work through and apply to your situation or the situation you're dealing with. So further to the coming into force of the regulations, this month, the Department of Business and Trade have published the guidance on the changes to the working time regulations and the new regime, which was introduced the 1st this month. The guidance is called Holiday Pay and Entitlement Reforms from the 1st of January 2024. I haven't included a link on the slides, but if you type into Google Holiday Pay and Entitlement Reforms from 1st of January 2024, the guidance will come up. And then you can just download the booklet. The guidance covers what's detailed in the slide. So in essence, the definitions of irregular hours worker and part-year worker, the accrual of statutory holiday entitlement for irregular hours and part-year workers for leave years beginning on or after 1st of April 2024, when holiday entitlement will be calculated at this 12.07% of actual hours worked in a pay period. The guidance also covers the calculation of holiday entitlement when a worker leaves a job partway through a leave year, requiring a pro-ratering of the annual statutory minimum entitlement. Also covered is the calculation of holiday entitlement for workers who work a fixed number of hours each week, but those daily hours vary, so that's quite a complicated scenario. Also, the calculation of statutory holiday entitlement accrued by irregular workers and part-year workers while on maternity or family-related leave or whilst off sick. Also covered in the guidance is the permitted circumstances as set out in the regulations where a worker is entitled to carry over holiday, and we've had a look at that. Also, the operation of rolled up holiday pay. And finally, the guidance covers the calculation of holiday pay for irregular hours workers and part-year workers, including which regular payments such as overtime, bonuses and commissions should be included. And again, we've had a look at that. As I say, the guidance is really helpful as it gives these working examples. And we'll have a look at some of the things in the guidance now. So starting then with the definition of an irregular hours worker and a part-year worker, as referred to in the guidance. A worker is an irregular hours worker in relation to a leave year if the number of paid hours that they will work in each pay period during the term of their contract in that year is, under the terms of their contract, wholly or mostly variable. So a couple of examples. Kevin, a hospitality worker who works a different number of hours each week. Kevin would qualify as an irregular hours worker if his contract says that the hours he works will be wholly or mostly variable in each pay period. Kevin's contract could be a casual contract, otherwise known as a 0 hours contract. And of course, in this country, we have seen a substantial increase in the use of 0 hours contracts. So that definition is helpful in confirming that these situations are caught by the new holiday rules. Another example, Paul, who has a rotating 2-week shift pattern where he works 15 hours in week 1 and 20 hours in week 2. He does not work overtime. Paul would not qualify as an irregular hours worker if his contracted hours are fixed during both week 1 and week 2. Given that Paul does not work overtime, it is not the case that his hours worked are wholly or mostly variable. Instead, Paul's hours are fixed, but he just works a rotating shift pattern. So those examples are helpful in us trying to identify when the new rules apply. Definition then of a part-year worker, I think a bit more straightforward, is a worker is a part-year worker in relation to a leave year if, under the terms of their contract, they are required to work only part of that year, and there are periods within that year during the term of the contract of at least a week which they are not required to work and for which they are not paid, and that's key. This includes part-year workers who may have fixed hours, for example, teaching assistants who only work during term time and who are paid only when working. Now, in quite a few of the education sector, we will see, or you will see, the teaching assistants or particularly teachers on salaries whereby they are paid each month, even though they are only required to conduct their duties during term time. Those contracts aren't caught by the new rules because of the fact that they receive payment every month. There's no weeks in which they do not receive a payment. They may not work, but they still receive a payment. So it's not those situations.
Thing died. I was having to reconnect it. So.
It's only the term time contracts that are paid on a term time basis that are caught.
So Keeley, would you qualify as an do they qualify as irregular working if they do uncontracted overtime on a regular basis above their normal contracted hours, where the overtime can vary each week?
Yeah, and I suppose that's the big question, isn't it? I think it becomes an issue of whether or not that overtime payment becomes becomes expected. It's regular and it's expected and becomes in effect the normal course of events. If it does, then yes, they could be caught.
Okay.
In which case, then you're looking back on the previous 52 weeks to calculate holiday pay, which is probably what the employer is currently doing anyway. So they may not need to change anything, but yes, they could be caught by this.
Okay. And what would a minimum hours contract worker be classed? So somebody said, for example, sorry, I've just lost the question. Somebody else asked the question. If a contract states minimum of 4 hours per week, but they can be put on longer shifts each week, i.e. 8-hour shift.
Yeah, so if you're looking back and they're working different hours each week, then I would say they're an irregular hours worker. Because they have a minimum amount of expected hours to work, but the hours that they work are irregular. Yeah.
Okay. Next question for you. Emily's asked, can we choose to pay 12.07% on all 5.6 weeks, even though they're classed as different pots?
Yes. Yeah. So
we work on a number of bank holidays in the distribution centre that they're in.
Yeah, I mean, yes, you can. Yes, you can.
Lovely.
Yeah. Okay. Well, I mean, to be honest, if you're using a 12.07% calculation, I don't think you need to worry about the differentials between 4 weeks and 1.6 weeks. The 4 weeks and the 1.6 week differentials only apply really to regular hour workers working regular hours, maybe salaried or, fixed hour workers. So don't worry too much about that if you're using the 12.07%, because that works into it. The calculation works in 5.6 weeks anyway.
Fab. One more question for you before we go on, Keeley. Jane's asked, their term time only staff are paid for term time, but their salaries are paid over 12 equal monthly payments. So they receive pay every month, but they're not.
Yeah, I don't think they're caught.
But not paid for every month. She said, I assume these staff can be rolled up.
No, I don't think they can. And that's the tricky area on this, because they're salaried. So they're being paid each month. There is no week in which they receive no payment.
No.
Yeah. So I don't think they're caught by it. Now, if the employer, and I'm sure this is going to lead to a lot of employers questioning it, if the employer wants to revisit their holiday calculations for term time workers to ensure that they're paying a proportionate amount of holiday compared with a standard regular 52-week worker or 46.4-week worker, then they might want to do that. But that would involve a renegotiation of the contract. So I think that's another piece of work that needs to be done. But no, if they are receiving a regular monthly payment throughout the year, there are no weeks in which the worker doesn't receive pay, in which case they won't fall into this definition.
Okay, thank you. I hope that helps, Jane.
Come back to me if it doesn't, because I know the point you're making is confusing, and I think, as I say, it's going to lead to these salaried monthly workers who only work term time, the holiday pay entitlement being revisited by employers to ensure that proportionality. Okay, so we've looked at those definitions. I think I was about to give you an example of a part-year worker. So Melanie, a seasonal worker in the farming industry who only works and gets paid during spring and summer months. So that would be a part-year worker. Melanie would qualify as a part-year worker if her contract reflects that there are periods of time that last more than a week when she is not contracted to work and does not receive pay. Another example given is Ian, who is paid an annualised flat salary over 12 months, but has periods of time that last more than 1 week where he is not working, which is exactly the same situation as the lady who's just raised the question. Ian would not qualify as a part-year worker if his contract reflects that there are weeks where he is not working and there are no weeks where he does not receive pay. Ian would need to not receive pay during the periods he is not working in order to be classified as a part-year worker. So that is directly on that lady's point who raised the question. Moving on then to section 3 of the guidance, which deals with holiday entitlement for irregular hours workers and part-year workers. And firstly, how statutory holiday entitlement is accrued. So that we're looking just at accrual now, accrual of holiday. So the guidance states that for workers who are not regular workers or part-year workers, there is no change in how their statutory holiday entitlement is accrued. The method remains so that in the first year of employment, workers receive 1/12 of the statutory entitlement on the first day of each month. After the first year of employment, a worker gets holiday entitlement based upon their statutory and contractual entitlement. The worker's holiday entitlement will be based upon the proportion of a week which they're contracted to work, and this is known as proratering. So if the worker works 4 days a week and a full-time worker works 5 days a week, the worker will be entitled to 80% of the full-time worker's entitlement. So that's what we're used to, and that remains the same. For irregular hours and part-year workers, for leave years that begin on the 1st of April, for irregular hours and part-year workers, for leave years that begin before the 1st of April 2024, so before the new rules come into place, holiday entitlement will continue to be calculated in the same way. So in essence, it's based on entitlement of 5.6 weeks per year. And as I said, under the Harper case, proportionality, the factual situation is that when using that calculation, irregular workers and part-year workers will end up receiving a higher proportion of holiday compared with regular workers. For leave years beginning on or after 1st of April 2024, the new accrual method for the irregular hour workers and part-year workers in the first year of employment and beyond is that holiday entitlement for these workers will be calculated at the 12.07% of actual hours worked in a pay period. So the guidance is just confirming that. So for example, Jill works irregular hours and is paid monthly. Her leave year starts on 1st of April 2024. She is entitled to the statutory minimum holiday entitlement only. In June, Jill works 68 hours. To work out how much holiday she accrues in June, you will need to calculate 12.07% of 68 hours. So you divide the hours worked in the pay period by 100. That is 68 divided by 100 gives us 0.68. Then we multiply that answer by the 12.07. So 0.68 times 12.07 equals 8.2076, then round up or down to the nearest hour. So 8.2076 becomes 8. Therefore, Jill accrues 8 hours of holiday during the month of June. And gets paid for it if that's what you decide to do. But that's the amount of hours she accrues. So you either pay it under the rolled up holiday pay, which we'll come on to again in a minute, or you make a note of it on your systems, and then she can take it when she requests to take holiday. Just something to note on this then, the hours can be rounded down to 0 if it is less than 30 minutes, but will be rounded up to 1 hour if it is 30 minutes or more than 30 minutes. And as I've already said, the 12.07% figure is based on the fact that all workers are entitled to 5.6 weeks leave. This means that a worker's total working weeks in a year is 46.4, 52 weeks in a year minus 5.6 weeks. So 12.07% of 46.4 is 5.6 weeks. The 12.07% figure is based on the statutory minimum holiday entitlement, 5.6 weeks. But please be aware that an irregular hour or part-year worker may be entitled to more than the statutory minimum holiday entitlement if this is specified in their contract. So obviously that will then change the calculation if that's the case. The accrual method to work out entitlement that we've just looked at will apply to an agency worker if the agency worker's arrangements fall within the meaning of an irregular hours worker or a part-year worker as per the new definition which we've just looked at. An agency worker who is not an irregular hours worker or a part-year worker will continue to accrue their holiday in the same way as now, i.e. 1/12 of their entitlement at the start of each month. So that gives us a bit of a rundown then as to how we accrue. The next section of the guidance, section 3.2, deals with leave entitlement when leaving a job part-way through the leave year. This remains the same. So in effect, it will be necessary for us to calculate the worker's full annual leave entitlement, work out the proportion of the leave year in employment, and then pro rata based on the proportion of the year in employment. There are some really good examples of this in the guidance that can assist you if and when you come to a situation where an employee leaves partway through the year, and you can just work through those examples and use them to help you to make the relevant calculations. The next section of the guidance is section 3.3, which deals with the situation where a worker works a fixed number of hours per week, but not the same number of hours per day. So that's quite a tricky situation. The guidance details how to calculate such workers' holiday entitlement. In effect, the guidance details that the workers' holiday entitlement should be calculated in hours, and then those hours applied then to the days that the worker wants to take as holiday. But as I say, go to the examples, work through them and use those examples to help you make the relevant calculations for your business. The next part of the guidance is section 3.4, which relates to calculating statutory holiday entitlement accrued by irregular hours and part-year workers while they're on maternity leave or on sick leave, which I think will be useful to have a look at. So some irregular hours and part-year workers may take maternity or family-related leave or be off sick within the annual leave year. Whether a worker can take maternity leave or family-related leave depends on their status, because maternity leave can only be taken by employees. It doesn't apply to workers. So just bear that in mind. Maternity or family-related leave includes leave such as maternity leave, paternity leave, shared parental leave, and adoption leave, all applicable to employees. During these absences from work, a worker would continue to accrue leave, and annual leave cannot be taken during a period of maternity leave. Some other types of family-related leave, an employee can take blocks of leave in between, but obviously maternity leave they can't. Under the new rules, a calculation method has been introduced for leave years beginning on or after 1st of April 2024 to help employers find out how much leave is accrued by their irregular hours workers or employees or part-year workers in such circumstances. So the method uses a 52-week relevant period involving employers looking back and working out an average of hours worked across that period to determine what period of leave should be deemed to have accrued during the during the maternity leave, family-related leave or sick leave. The relevant period would run from the day before the worker starts maternity leave or family-related leave or takes a time off sick, going back for 52 weeks. When calculating the average weekly hours worked, employers should not include weeks where the worker or employee is on maternity or family-related leave or is off sick for any amount of time. So you discount those weeks, and instead you have to look back a further week or weeks to get you the 52 weeks of data that you need. An example is given in the guidance. Harriet is a part-year worker who is entitled to the minimum 5.6 weeks statutory holiday. Over a 52-week period, she worked in 26 weeks for a total of 1,032 hours. She then took the following 40 weeks off as maternity leave. So what do? Firstly, calculate the average number of hours per week that Harriet worked during the 52-week relevant period before she started maternity leave. So she worked 1,032 hours. You divide that by 46.4 working weeks, which equals 22.241 hours, rounded up to the 3 decimal places. Then you calculate the number of hours of annual leave accrued per week of the maternity leave. So 22.241 hours divided by 100 times the 12.07% figure equals 2.684, rounded to 3 decimal places. Then you calculate the total number of hours of annual leave accrued while on maternity leave. So it's 2.684 hours times the 40 weeks of maternity leave that she takes, which equals 107.36 hours. And you round up, so finally you round up or down to the nearest hour. So 107.36 becomes 107. Therefore, Harriet accrued 107 hours of holiday entitlement while on maternity leave. So when you work through these examples, it becomes much clearer as to how to make the calculation. Most employers will be using this calculation for workers who only take a single period of leave, such as maternity leave. But it is possible that some workers who are eligible may take multiple periods of maternity or family-related leave or be off sick multiple times during the 52-week relevant period. For example, a worker may take maternity leave, return to work, then be off sick at some point within the next 32 weeks. So employers will need to take into account these previous periods of maternity or family-related leave or time off sick when calculating the statutory holiday entitlement accrued during subsequent periods. And this may mean that the relevant period needs to go back further than the 52 weeks, up to a maximum of 104 weeks. If a worker has not worked with the employer for long enough and there are fewer than 52 weeks to take into account, then the relevant period is shortened to that lower number of complete weeks. So there are further examples in the guidance of when these situations occur. So you'll see in the guidance, there's situations where employees have taken maternity leave, then come back, then taken another period of maternity leave, and making the necessary calculations in those situations is all detailed in the guidance. But in effect, what you're doing is you're looking back 52 weeks, discounting the periods of family leave, and that may mean that the periods are shorter, that you can the data is shorter, is lower than a total of 52 weeks. As I say, the stopgap here, you only look back a total of 104 weeks, so 2 years in total.
Okay. Keeley, I've just got a couple of questions before you move on, if that's
Yeah.
okay. So Claire's just asked, following on from previous things you were saying, so if an employer gives more holiday than statutory, the 12.07% won't apply. So for example, if one of her employers offers 33 days leave, so 1 extra week, then the calculation would be 52 weeks less 6.6 weeks, which takes you to 45.4 weeks. Yeah. So it'd be calculated at 14.5% rather than the 12.0.
Yeah, that's right. I agree with that.
Okay.
Yeah.
Fabulous.
Yeah.
And then Tracy's asked, she said she was always advised that you weren't able to allocate holiday and holiday pay whilst an employee was on long-term sick leave. She thought that they had to request that they wanted to take the holiday leave rather than you allocating it.
Yeah, no, that I think we'll look at the contract. The contract usually says that an employer can allocate periods of annual leave to an employee. If the contract is silent on that, the working time regulations enable an employer to do it. So there is prescribed that if an employer is doing it without a contractual right to do so, then the employer has to give, I think it's double the notice of the period of leave that the employer wants the employee to take. So if the employer wants the employee to take 1 week leave, then they have to give 2 weeks notice of that, and that's in accordance with the regulations. As I say, there might be a contractual right to do it without any particular notice. So have a look at the contract first, but otherwise it's double the period of leave.
Great, thank you.
So we've done Harriet, haven't we? Here we are, yes. We're going to move on then to look at, just really briefly, the carryover leave, because we've already done it when we looked at the regulations. But the guidance, what it does, it just pads it out a bit more and gives an example and further explanation really as to the situations when an employee will be able to carry over that period of annual leave. It also confirms the difference between the 4 weeks and the 1.6 weeks. So I'm not going to go through it again. Have a look at the slides if you want to later on, or the guidance on it. But we've already covered it when we went through the regulations. We've also covered, when we looked at the regulations, the COVID carryover, and now the situation where that now stops as at the end of March. Just to mention on that, if an employee or worker leaves before the end of March, then they should be paid in lieu of any accrued but untaken COVID carryover leave. And then just moving on then to what I think is the more important aspects of the rules is the payment. So we've looked at accrual, 12.07%. And now we're going to look at, well, how do we pay it and when do we pay it? So we have looked at it briefly in the regulations. As I say, the guidance helps us a bit more on it. It confirms the position that I've already referred to and stated that after 5.6 weeks statutory holiday that workers are entitled to, 4 weeks of the entitlement come from the directive must be paid at the worker's normal rate of pay, and then the 1.6 weeks can be paid at basic pay. Basic pay being the basic remuneration. Somebody asked whether or not they can pay all of the 5.6 weeks at at the normal remuneration? Yes, they can. And if there is going to be a difference in how you pay 4 weeks and 1.6 weeks, then make sure it's covered off in the contract. But yes, you can still differentiate on the payments. Normal pay being, payments that are intrinsically linked to the contract, commission, regular paid overtime or regular worked and paid overtime, and payments in respect of professional and personal status or qualifications. So moving on still on the aspect of payments, so how do we pay it? The guidance gives us then these two options, or the regulations give us these two options. And the first one is rolled up holiday pay. We've seen that rolled up holiday pay allows the employers to include an additional amount of pay with every pay slip to cover a worker's holiday pay, as opposed to paying holiday when a worker takes the annual leave. This means that the worker doesn't get paid when they take holiday, but they shouldn't be prevented from taking holiday. They just won't be paid when they take the holiday. The guidance confirms that the regulations allow employers to use rolled up holiday pay as an additional optional method for calculating holiday pay for irregular hours and part-year workers only, and for leave years beginning on or after 1st of April. As we know, the calculation of the rolled up holiday pay is 12.07% of the worker's total pay in the relevant pay period. And a pay period is the frequency at which the worker gets paid. That is weekly, fortnightly, monthly, and the like. If employers intend to start using the rolled up holiday pay, they should check their contracts to make sure that you're not making fundamental changes to the contract. And employers should tell their workers if they intend to start using the rolled up holiday pay method. Also, the payment must be clearly marked as a separate item on each payslip. Employers of agency workers must include the information in the agency workers' key information document. The holiday pay should be paid at the same time as the worker is paid for the work done in each pay period. And if a worker who receives rolled up holiday pay goes off sick or takes maternity or family-related leave during a pay period, their rolled up holiday pay should be calculated according to the average amount of the worker's total earnings in each pay period during the 52-week relevant period, which is what we've just looked at. So an example, Hannah works irregular hours and is paid weekly. Her hourly rate is £10.42 an hour for all shifts. In the week, 1st of October to 7th of October, Hannah worked 35 hours. To work out how much rolled up holiday pay Hannah is entitled to, you'll need to calculate 12.07% of Hannah's total pay in this pay period. So firstly, you multiply the hours worked by the hourly rate to find Hannah's total pay in this pay period. So 35 hours times £10.42 per hour is £364.70. Then divide that answer by 100, rounding to the nearest pence. So £364.70 divided by 100 gives us £3.65. Then you multiply that answer by 12.07%. So £3.65 times 12.07% gives us £44.0555. And that becomes £44.06. So Hannah is entitled to receive £44.06 rolled up holiday pay in her pay slip for the period 1st of October to the 7th of October. There's a further example in the guidance dealing with holiday entitlement when a worker is paid fortnightly and when different shift rates apply on those fortnightly shifts, which is very complicated but really helpful when you're having a look and deciding how to pay and how to work it all out. So the alternative option is to pay when the employee worker takes holiday. And that's section 5.3 of the guidance. It details the alternative method to paying rolled up holiday pay, where the worker has irregular hours or works part of the year. The alternative option is for employees to pay workers holiday pay when holiday is taken. And to calculate the workers' holiday pay, the employer will need to use an average from the last 52 weeks in which the worker has worked and been paid. So if a worker has not been in employment for long enough to build up the 52 weeks worth of pay data, their employer should use however many complete weeks of data they have. So for example, if a worker has been with their employer for 26 weeks, that's what the employer should use. Well, they haven't got any other option because there's no other data. Now, if a worker takes leave before they have been in their job a complete week, and that happens, then the employer has no data to use for the reference period. And in this case, the reference period is not used. Instead, the employer should pay the worker an amount which fairly represents their pay for the length of time the worker is on leave. This is going to be difficult. In working out what is fair, the employer should take into account the worker's pay for the job, the pay already received by the worker, if any, and what other workers doing a comparable role for the employer or for other employers are paid. But how far back should employers go? And I have alluded to this before, that there is a cap. There is a cap that an employer will need to look back in order to reach the 52 weeks of data. And the cap is 104 weeks or 2 years. Any weeks that are before the 104 complete weeks prior to the first day of workers' holiday are not included. And in this case, the reference period is shortened to however many weeks are available in 104-week reference period. Employers should still only count back as far as is needed to achieve the 52 weeks worth of pay data if this is less than 104 weeks. So it's a cap, it's just a cap. As I've said, where a worker has been employed by their employer for less than 52 weeks, the reference period is shortened to the number of weeks of their employment. The reference period must only include weeks for which the worker was actually paid. It must not include weeks where they were not paid as they did not work. Where this gives less than 52 weeks to take into account, the reference period is shortened to that lower number of weeks. So for example, if a worker started work 30 weeks ago, employers should use pay data from as many of those weeks that the worker was paid to calculate the worker's holiday pay. Also, any weeks during which the worker took time off sick, or they were on maternity leave or family-related leave should also be excluded from the reference period. And instead, additional earlier paid weeks should be included to achieve the 52 total week reference period. What's a week for the purpose of the reference period? The holiday pay reference period starts from the last whole week ending on or before the first day of the period of leave. This will typically be a week from Sunday to Saturday, but there is an exception for workers whose pay is calculated weekly by a week ending on a day other than a Saturday. So in these cases, a week is treated as ending with that other day. For example, if a worker's pay is calculated by a week ending with a Wednesday, then the employer should treat a week as starting on a Thursday and finishing on a Wednesday. So it's about when the employee is paid. Yes, sorry, I didn't move on with the slide there. So that just details what I've just said. So the cap of 104 weeks and the reference period and then the week, what is a week at the end of that slide. Just looking then at a few examples on this, and I don't I don't propose to look at all of those examples, but the first example, Joe has been working for his employer for over a year with variable pay. Joe's holiday pay is averaged from his pay over the past 52 weeks. Rachel started with a new employer 20 weeks ago and is on variable pay. As Rachel's employer does not have 52 weeks worth of data to use, they use what data is available. As such, Rachel's holiday pay is averaged from her pay over the past 20 weeks. Ben works irregularly for his employer and over the past 104 weeks has received pay in 45 of them. As Ben only has 45 applicable weeks in the past 104, Ben's employer calculates his holiday pay using an average from his pay over the 45 weeks in which he earned pay. And lastly, Amy works irregularly for her employer, and in the past 104 weeks, she has earned pay in 75 of them. As Amy has at least 52 applicable weeks in the last 104, her holiday pay is averaged from her pay in the most recent 52 complete weeks worked. Just to end this section then on holiday, I'll just finish with reference to section 5.5 of the guidance. This confirms that if an irregular hour worker or part-year worker does not take their holiday, accrued holiday entitlement by the time they leave their employment, they should be paid for this untaken holiday, known as payment in lieu. And this should be calculated by working out the individual's remaining holiday entitlement and then working out their holiday pay for this. Employers should remember to deduct any holiday taken from the total holiday entitlement to correctly calculate the remaining holiday the worker is entitled to. So that completes then our section on the new holiday rules. I'm just conscious of the time, and for some reason my time hasn't come up on my slide. Eloise, where are we on the time? Oh, I can't hear you. Sorry,
Sorry, it's 3:25.
Oh, so we've gone well over the hour, haven't we? Well, I've got a bit more to do on the statutory new legislation that's coming into force. What do you want me to do? Do you want me to pick it up with you at another time, or?
I don't mind. If you have time, you can carry on and then we can send everybody the recording because some people have had to go.
Yeah. Yeah, well, I'm happy to do that. Yeah. Okay. So, other changes then to come into force, and we'll do a whistle-stop tour of this. But I mean, it's amazing really how much we've got to grapple with this year. So, firstly then, in the areas of working time and TUPE. And under the Employment Right Amendment, Revocation and Transitional Provision Regulations 2023, the regulations came into force on the 1st of January of this month, like a lot of new legislation did. So with regards to working time, the regulations have clarified that employers are not required to keep records relating to working hours and rest periods. Thank goodness. This is something that Europe said that we should be doing, and it has now been confirmed that we don't have to. So our existing Regulation 9 of the Working Time Regulations requires employees to keep adequate records to show compliance with two rules. And the first rule is the 48-hour weekly working rule, unless there's an opt-out. And also some of the night rules. So we have to keep adequate records to ensure our compliance with those rules. The new regulations retain the scope of the existing record keeping duty, i.e. the adequate records being kept, but clarify that records may be created, maintained and kept in such manner and format as the employer reasonably thinks fit, and that an employer need not record each worker's daily working hours in order to comply with a Regulation 9 duty if the employer is able to demonstrate compliance without doing so. So that does really help us in terms of record keeping, and hopefully will ensure that we're not overly burdened with more administrative requirements about working time. With regards to TUPE, Transfer of Undertakings Protection of Employment Regulations, of course, there have been some changes, and again to assist employers with regards to transfer. So under TUPE, there is an obligation on employers to inform and in some cases consult with appropriate representatives of the affected employees in respect of a transfer of a business, transfer of an undertaking, or in a contracting out situation or an outsourcing situation. If the employer doesn't recognise a trade union or already have elected representatives in place, then under TUPE, it's a requirement that the employer elects appropriate representatives to act for the affected employees in the transfer or the contracting out situation. Currently, micro businesses with fewer than 10 employees may inform and consult affected employees directly about the transfer and therefore don't have to elect employee representatives. Larger businesses, however, are required to arrange elections for affected employees to elect new representatives if they are not already in place, which obviously can add to the complexity and the length of transactions involving TUPE. Under the new law, the government has removed the requirement to elect employee representatives for employers with fewer than 50 employees and employers of any size involved in a transfer of fewer than 10 employees. In either of these cases now, or from July actually, the employer will be able to consult directly with the affected employees where there's no existing employee reps in place. And as I say, that change will take effect on the 1st of July this year. Secondly, then, there are quite a few changes coming in respect to family-friendly rights, and we have looked at these before in our updates. The first one I want to deal with is the Protection from Redundancy Act, Pregnancy and Family Leave Act, which came into force in July last year. It contains a power for regulations to be made to extend the current right of employees on maternity leave or adoption leave or shared parental leave to be offered suitable alternative vacancies in a redundancy situation ahead of others. And it extends that right to employees during pregnancy and for those taking additional relevant leave. So it's an extension of that right to be offered suitable alternative vacancies in a redundancy situation ahead of others. The regulations that bring the Act into force have been published, and they detail the new requirements or the new law in detail. So, firstly, with regards to pregnancy, the redundancy protection will start when an employee tells their employer that they are pregnant. So that is when they become protected. And that is when the employer has an obligation to ensure that they offer suitable alternative work ahead of others in a redundancy situation to them. So now, as soon as they tell the employer that they're pregnant. Also in relation to maternity leave, the additional protection will apply for 18 months after the expected week of childbirth. In respect of adoption leave, the additional protected period ends 18 months after the child's placement or the date they enter Great Britain in the case of overseas adoption. And finally, in relation to shared parental leave, the protection only applies to those taking 6 or more consecutive weeks of shared parental leave, but who have not taken maternity or adoption leave. And in these situations, then the additional protected period ends 18 months after the date of the child's birth or placement. So it's an 18-month period that's now protected. Of course, that will include some of the maternity leave and adoption leave in some cases, but it obviously extends the existing protective periods. With regards to the date when these new rules will apply, this will occur where the employee notifies their employer of their pregnancy on or after the 6th of April of this year, and to maternity and adoption leave periods ending on or after 6th of April this year. In respect of shared parental leave lasting 6 or more consecutive weeks, the new rules will apply to a leave period starting on or after 6th of April this year. Moving on then to the Carers Leave Act. It received royal assent last year. We have looked at it in previous updates. The draft regulations have been laid before Parliament, and they will come into effect. Everything will come into effect on the 6th of April this year. The regulations provide that an employee who has a dependent with a long-term care need may take 1 week's unpaid leave to provide or arrange care in each rolling 12-month period. The leave may be taken in either individual days or half days, up to a block of 1 week. The required notice period is either twice as many days as the period of leave required, or 3 days, whichever is the greater. The notice does not need to be in writing. It should be noted that an employer cannot require evidence in relation to the request before granting the leave. So that's something to note. An employer may waive the notice requirement where the other requirements of the regulations have been met. An employer cannot decline a request altogether, but may postpone a carer's leave request where all of the following apply. It's detailed on the slide. The employer reasonably considers that the operation of the business would be unduly disrupted if it allowed the leave during the requested period. The employer allows the employee to take a period of carer's leave of the same duration within a month of the period initially requested, and the employer gives the employee a written notice within 7 days of the initial request, setting out the reason for the postponement and the agreed date on which the leave can be taken. So it's a postponement rather than a refusal of the request. During the period of carer's leave, an employee is entitled to the benefit of all their terms and conditions, apart from remuneration. So this is unpaid leave. And therefore, unless an employer decides to pay, then it doesn't need to. And as with other types of statutory leave, an employee will be protected from detriment and dismissal attributable to the fact they took or sought to take this leave, this carer's leave. But what's the meaning of dependent and long-term care? A person is a dependent for the purposes of carer's leave if they are a spouse, they're a civil partner, they're a child or a parent of the employee. They live in the same household as the employee, otherwise, this is or live in the same household as the employee, otherwise than by reason of being the employee's boarder, employee, lodger or tenant, or reasonably rely on the employee to provide or arrange care. And it's interesting, isn't it, that it's parent of an employee, which is obviously going to catch many situations. A dependent has a long-term care need for these purposes if any of the following apply. They have an illness or injury, whether physical or mental, that requires or is likely to require care for more than 3 months. They have a disability as defined under the Disability the Equality Act and the definition of disability, which obviously we've looked at on many occasions during our updates. It's quite a wide definition. And they require care for a reason connected with their old age. So there are I think those categories are pretty wide and will catch most situations. So I think that is something that is going to be used and we'll see being used by employees soon after it comes in on the 1st of April. Just a quick mention of the protection and harassment rules that are coming in October. They'll amend the Equality Act to introduce a duty on employers to take reasonable steps to prevent sexual harassment of their employees. What are reasonable steps? It's got to include some training and it's got to include an anti-harassment policy, working anti-harassment policy and procedure in the workplace. Other changes then involve the flexible working provisions. We've considered these again before, but in essence, the new provisions include a request or include the right to request flexible working from day one of employment rather than after 26 weeks, which is currently the position. Employees will also be able to make 2 requests in any 12-month period, which is up from the present one. In addition, employees will no longer have to explain the effect of the change that they're requesting, and employers will have to make a decision about a request within 2 months rather than 3, which is what applies at the present time. The statutory reasons that an employer will need to rely on in rejecting any request remain the same. So everything else remains the same. It's those changes. Just a very brief mention of predictable working and this legislation. This act is aimed at increasing certainty for gig economy workers around their working patterns by introducing a right for workers and agency workers to request more predictable terms and conditions of work. And then just to, well, penultimately leave on is the reference to all the new paternity leave regulations that have been published. So after announcing proposals to make changes to paternity leave rights in the summer last year, the government has now published the draft regulations due to come into force in April. Regulations make the following changes. Employees will be able to take their 2-week paternity leave entitlement as 2 separate weeks in 2 separate 1-week blocks, rather than having to take just 1 week in total or 2 consecutive weeks, which is what's required at the present time. Employees will be able to take paternity leave at any time in the 52 weeks after the birth, rather than having to take leave in the 56 days following. And employees will only need to give 28 days notice of their intention to take paternity leave, which is reduced from the previous position that required notice to be given 15 weeks before the expected week of childbirth. The regulations are stated to apply to all cases where the expected week of childbirth is on or after 6th of April of this year. And these proposed changes are therefore due to take effect at the same time as the other family-friendly rights that we've just looked at. There will, of course, be corresponding rights in respect of adoption cases. And just to finish off then with the, as we all know, these large increases in the national minimum wage and the other increases. So we've got the biggest announced increases for a very long time. It's the first time the rates have actually increased by more than £1. So we've got national living wage going up by £1.2p up to £11.44, and then the other ones, 18 to 20-year-old rate increases to £8.60, 16 to 17-year-old rate increases to £6.40, both up by £1.11, £1.12, and apprenticeship rates increases to £6.40, up by £1.12. New rates apply from April 2024. So what do? Don't panic. Don't panic. You've got the information, so it's now just working through, isn't it? And seeing when and if the new rules apply to you in terms of the holiday arrangements, making the relevant communications at this time, because you've got a bit of time to work on the new holiday regulations, because obviously they don't come into force until the holiday leave year after 1st of April 2024. In respect of the other changes, updates to policies and procedures, and making sure that they're implemented in good time and they're published in your staff handbooks. And then to organise any necessary training on harassment back end of the year, really, starting to think about doing sort of brief training on harassment, just to cover off that requirement under that new piece of legislation. So plenty to think about in our roles as usual. It's certainly not boring. And I'm very sorry I've gone over.
No, that's fine, Keeley. One question before we close the meeting. Sam's asked, can we ask why and who people are wanting carers leave for?
Yes, I think you can. I think it's just evidence, isn't it? Yeah. So it's what it says is you can't ask for evidence. So confirmation, whether that's from the dependent, I presume, or medical evidence, I suppose. But yes, I'm sure. Yes, of course. Ask who they're asking, who the dependent is, because you'll need that information in order to determine if it fulfills the criteria. So
Great.
yes.
Thank you. So lots and lots to take in, and lots of great information. So thank you, Keeley, for going through it with us in such detail. As usual, the slides and the recording will be sent out to you in the next week or so. But if you've got any questions that have come from today, feel free to email me, or it would make more sense probably emailing Keeley, and I'm sure she'd be happy to help and advise. But if there's any, if you want to give me feedback for any other topics that you'd like us to talk about, then feel free to contact me, and obviously we can get different topics. But thank you so much for your time and attendance today, and I look forward to speaking to you again soon at other HRHuddle events. Have a lovely afternoon.